This is going to be a quick introduction to the concept of agency. Some people will refer to it as employee-employer relationship, maybe respondeat superior, but all in all of these terms are somewhat used interchangeably in the law to basically illustrate the concept where an employer or a company can be held responsible for the actions of their individual employees. So we're going to discuss a few terms, give some examples, and try to explain each of those different concepts so that you can easily understand them. In the law, there's a concept called agency. An agency usually has two main players. There's the principal and the agent. One way to think about the principal is the person who's in charge. They're giving direction. They're giving orders. One way to think about the agent is the person who's receiving those orders and then fulfilling those orders. The principal is usually the boss, the agent, usually the employee. But there's a relationship between the two where one is directing the other and one is receiving those directions and then carrying them out. If those directions are carried out in a negligent fashion, then the principal can be held responsible for the actions of the agent. That's agency. So let's put that discussion regarding agency into context. A doctor might be an agent of the hospital. A truck driver might be an agent of the company that they're driving for. A construction worker operating equipment on a construction site might be an agent of the construction company. A police officer might be an agent of the police department. These examples go on, but the basics are, if the agent messes up or is negligent in some way, then the principal can be held accountable for the actions of the agent. So in Illinois, it's important to determine whether someone is actually an agent or employee of a principal, because they could be what's called an independent contractor. And the difference between an employee and an independent contractor usually centers around whether the principal has sufficient control over the person. If they do, then they're an employee or an agent. But if they don't, if there's separation and there's a line drawn where there's a distinction, that person could be an independent contractor. If they're determined to be an independent contractor, then there's a buffer or a little insulation between the actions of that independent contractor and that of the person who may have been giving them direction. Liability in that particular situation may not be able to be imputed upon the person. There's a whole bunch of different factors that go into determining whether someone is an employee or an independent contractor, but most of them center around the issue of control. The operative language is something along the lines of, did the person have the freedom to do the work or whatever was required on their own, or did they have to take the direction from the director or the principal? If they had to follow the direction, they're probably an agent. If they had the freedom to do the job the way they saw fit or according to whatever their expertise may have been, they're probably an independent contractor. So the difference, to sum up, between an independent contractor and an employee is that an independent contractor has a little bit more freedom. The employee, they have to follow the directions.